The West Virginia eviction notice. What is an eviction notice? Eviction notice, or notice to quit, is a letter sent by the landlord to the tenant notifying them that they should either take or stop a certain action or vacate the rented premises. Eviction notice can be of two types: conditional, when a tenant is given time to remedy the breach of the lease, or unconditional, when a landlord terminates the lease without any alternative options for a tenant. What should an eviction notice include? Information about the tenant and the landlord. The reason for sending the notice. The date by which the tenant should take or stop a certain action. The consequences of non-compliance. The date and way of notice delivery, and the landlord's signature in the form of certificate of service attached to the notice. How to evict a tenant in West Virginia. Non-payment and non-compliance notice. The landlord in West Virginia is not required to send the tenant an advance notice if the latter breaches the terms of the lease in any way. The law doesn't require them to give the tenant the time to correct the issue before starting an eviction proceeding. However, they can always choose to notify the tenant about the intent to evict them in a written notice. But if the tenant pays the past due rent along with the associated fees before the court hearing, the eviction process will stop. What if the tenant fails to comply? If the tenant fails to comply with the rules of the lease and landlord's requests, the landlord can file a complaint with the West Virginia Magistrate or Circuit Court. In Circuit Court, the filing fee is $200 statewide. In Magistrate Court, the fee varies from $30 to $50 depending on the amount of back rent or other damages caused by the tenant. Prior to the hearing, the tenant should be served with a summons and complaint by a person over 18 who is not a part of the upcoming hearing. They might file an answer if they aim at contesting the eviction within 5 days after receiving the summons. The tenant's failure to file an answer or appear for the hearing might result in judgment in favor of the landlord by default. If the court makes a judgment in favor of the landlord through hearing or by default, the court might order the sheriff at the final day of the court-ordered deadline to appear at the rental unit to remove the tenant. Or the court might issue a writ of possession if the tenant fails to move out by the court-ordered deadline.